Welcome to Know HIPAA's HIPAA Privacy and Security Overview for Employers. During today's presentation, we're going to provide a general overview of HIPAA, who it impacts, and specifically what it means for employers. We're going to discuss why it matters, particularly in light of potential penalties for noncompliance and current auditing activities. We will spend some time on the specifics of both the privacy and security rules, and finally we'll end by discussing what HIPAA requires in the case of a breach of unsecured protected health information, or PHI. Who does HIPAA impact? HIPAA impacts two primary groups, covered entities and business associates. Covered entities include healthcare providers, clearinghouses, health insurance companies, and most importantly for our purposes, employer-sponsored group health plans. Note that while HIPAA applies to group health plans regardless of funding arrangements, the requirements for each may differ, so it's important for employers to consider the funding arrangements for each type of plan offered. Business associates must also comply. Business associates may include firms working with covered entities, such as billing services, transcription services, third-party administrators, and brokers. I mentioned on the previous slide that the health plan itself is the covered entity. This can be a confusing distinction, but it's important. The employer itself is not subject to HIPAA. The health plans it sponsors are subject to HIPAA. In other words, the health plan itself is the covered entity, not the employer. But a health plan only exists on paper. The employer is the entity with employees, and therefore, practically speaking, the employer is the entity responsible for ensuring compliance by the health plan. This chart attempts to illustrate the relationship between the health plans, or covered entities, the employer, insurance companies, and business associates. If the health plan is self-funded, then the health plan is the sole covered entity, and the plan sponsor is required to ensure compliance with HIPAA. It can delegate some duties to a business associate, such as a third-party administrator, but the plan sponsor still remains on the hook for ensuring compliance by the health plan. In a fully insured arrangement, the health insurance carrier is also a covered entity. There is no business associate relationship here. Note also that business associates are responsible for making sure that any of their subcontractors also comply. Why does it matter? HIPAA is enforced by the Office of Civil Rights, or OCR, which is part of the Department of Health and Human Services. Historically, enforcement has been primarily complaint-driven. However, with the passage of HITECH in 2009, OCR was required under provisions in that law to conduct periodic compliance audits, which shifted the enforcement focus from a primarily reactive approach to a more proactive one. OCR completed its first phase of audits in 2011 and 2012. Approximately 115 covered entities were audited, and all audits included a site visit. At this recording, during the summer of 2016, the second phase of OCR's audits is currently underway. This round of audits includes both covered entities and business associates, and both desk and on-site audits. Given this increase in enforcement activity, along with the increase under HITECH in potential penalties that may apply for noncompliance, it is crucial for employers offering group health plans subject to HIPAA to ensure that appropriate compliance efforts are made. This chart provides a visual of OCR's enforcement activities, broken down by resolution type and year. Enforcement activity has been increasing on the whole, especially in recent years. HIPAA privacy rule. First, let's start with a general definition of protected health information, a term that we use a lot when talking about HIPAA. So what do we mean when we talk about protected health information, or PHI? PHI is defined as individually identifiable information relating to the physical or mental health of an individual that's created, maintained, or transmitted by a covered entity. For purposes of employer-sponsored group health plans, PHI really refers to individually identifiable information related to the health plan. For example, individually identifiable information related to a claim incurred under the health plan would be considered PHI. Note that it's not necessary that the information contain a diagnosis, code, or treatment information in order to be considered PHI. Under HIPAA, information is considered PHI if it contains any of 18 separate identifiers, which can be as broad as a first name or a date of birth. It's also important that PHI not be confused with other employee medical information that an employer may have access to, such as information an employer may have for purposes of administering FMLA or workers' compensation. These other types of medical information may still be identifiable and are still protected under laws such as the Americans with Disabilities Act, but although they should be safeguarded, they are not technically considered PHI. So what does HIPAA say about how PHI should be treated? First and foremost, HIPAA restricts the use of PHI. PHI may be used and disclosed only for certain purposes allowed by the law, or when the individual provides specific authorization, which must be in writing, to use his or her PHI. In the absence of an authorization, PHI may be used for purposes of treatment, payment, or healthcare operations. This means that a plan can use PHI for legitimate plan administration purposes, such as facilitating enrollment or adjudicating claims. However, unless specifically required or permitted by law, other uses of PHI are strictly prohibited. HIPAA also requires that even when uses and disclosures of PHI are allowed, only the minimum necessary is used to complete the task. Therefore, if an employee carrying out plan administration functions has a question about a particular claim, it would not be appropriate to send a spreadsheet to another employee or to a business associate containing information about that claim along with 20 other claims. Another area where minimum necessary comes into play is with respect to access to PHI. Employers should ensure that only employees who need access to PHI to perform their job functions are granted such access, and that such access is limited to the minimum necessary to perform their job functions. Employers sponsoring health plans encounter many instances where requests for PHI are made, and it's important to understand when disclosures are permitted without an individual's written authorization. Generally, PHI may only be disclosed to the individual who's the subject of the PHI. This means that if a spouse calls in with a question about an employee's claim, no information may be provided to the spouse without a written authorization from the employee. The same rule would apply to an employee inquiring about a claim for his or her adult child who is a dependent on the plan. This is also why, if you as an employer attempt to contact a healthcare provider in order to assist an employee with a claims-related issue, that provider will likely require an authorization before it discloses information to you. However, plan sponsors may send certain information to subscribers, such as explanations of benefits, or EOBs, that contain limited information about dependents on the plan. This is generally considered to fall under the exception for uses and disclosures for treatment, payment, and healthcare operations. The most important point to remember in all of this is that when there is any doubt about whether a particular use or disclosure is permissible, ask your privacy official. It may cause a small delay in the short term, but it could prevent a much larger headache down the road. We're going to spend some time now walking through each of the individual rights afforded under HIPAA. First, access to PHI. This refers to an individual's right to obtain copies of his or her PHI that are maintained by the plan. Amendment of PHI refers to an individual's right to request that corrections or other changes to his or her PHI be made when the individual believes that the information is incorrect. An individual also has the right to request an accounting of disclosures, which includes all disclosures of PHI made within the past 6 years that were not for treatment, payment, or healthcare operations or pursuant to an authorization or otherwise permitted or required by law. An individual has the right to request that it receive communications confidentially or via alternative means, for example, to a post office box instead of a home address. Plan sponsors must accommodate reasonable requests for confidential communications. An individual has the right to request restrictions on the use and disclosure of PHI for treatment, payment, or healthcare operations purposes. Generally, the plan is not required to agree to such a request, but if it does agree, it must ensure that it carries the request out. An individual has the right to submit a complaint regarding the plan's privacy practices or perceived violations. Contact information for submitting such complaints must be included in the Notice of Privacy Practices, and the employer, as plan sponsor, may not retaliate against any employee who makes a complaint in good faith. As we will discuss in more detail later on, an individual has the right to be notified in the case of a breach involving his or her PHI. Finally, individuals have the right to execute a written authorization that permits a covered entity to use and disclose his or her PHI in a way that would not otherwise be permissible. For example, an individual might execute an authorization permitting the health plan to speak with his or her spouse about treatment or claims. Written authorizations must meet certain criteria, such as including a purpose, an expiration date or event, and a signature. And they must include certain statements, such as the individual's right to revoke the authorization and how to request a copy of the signed authorization. It's very important to ensure that all of the requirements for a written authorization are met. Otherwise, the authorization may not be considered valid, and any disclosures made pursuant to the authorization would be considered unauthorized disclosures of PHI. In addition to having a basic understanding of how PHI may be used and disclosed and what an individual's rights are with respect to their PHI, plan sponsors must be aware of many other specific requirements under HIPAA. For example, covered entities are required to designate a privacy official who's responsible for overseeing implementation of the plan's policies and procedures and acting as a point of contact for inquiries or suspected breaches. If the plan sponsor is involved in administering the health plan and therefore requires access to PHI to perform some of those plan administration functions, the plan documents must be amended to include specific language authorizing the disclosure of PHI by the plan to the plan sponsor, and the plan sponsor must certify that it will abide by those requirements. HIPAA P&Ps, policies and procedures, are key. Many employers are already doing most of what HIPAA requires from a security perspective, for example, but they don't have those processes documented. And sometimes changes are needed to ensure that procedures apply to PHI. Training must be provided to all workforce members that require access to PHI, including employees, volunteers, interns, and trainees. Training should be provided upon hire and periodically thereafter. Finally, a notice of privacy practices must be issued to all new enrollees, and a reminder regarding the availability of the notice and how to obtain it should be issued at least once every 3 years. If the covered entity maintains a website that provides information about its benefits, the notice should be maintained on that website as well. Moving on to the security rule, we'll start with the general overview. The security rule was issued a few years after the privacy rule and contains 22 standards within 4 categories that must be addressed. The standards apply to all covered entities and business associates. However, when plan sponsors consider how best to implement these requirements, they should take into account the size, complexity, mission, and purpose of the organization with respect to the plan's EPHI. A small company offering a health plan to its employees may take a very different approach to implementing HIPAA's security standards than a large hospital would. This slide sets forth a full list of the standards along with their implementation specifications. We won't discuss all of these, but a few things should be noted. First, all implementation specifications are either required, denoted on this page by an R, or addressable, denoted by an A. Addressable does not mean optional. It simply means that there is some additional flexibility permitted for meeting the requirement, as OCR recognizes that alternative measures may be appropriate in some cases. Deciding which measures are reasonable and appropriate should be based on information an organization has as a result of its risk analysis, which is another one of the requirements under the security rule. The risk analysis is critical in helping an employer map out exactly how PHI flows, where it is housed, who has access to it, and identifying risks and vulnerabilities with respect to that PHI. The results of the risk analysis drive the employer's compliance program and should be carefully documented. In addition to a risk analysis, developing written policies and procedures is key, as I mentioned before. Many employers are already doing much of what HIPAA requires from a security perspective, but don't have those processes documented. Maintaining written policies and procedures is a crucial part of ensuring HIPAA compliance. Another crucial compliance requirement is designating a security official who is responsible for overseeing implementation of security procedures, acting as a point of contact for security-related concerns, and conducting periodic evaluations on the organization's security measures. Employers should ensure that their workforce members are aware of the expectations with respect to use of the company's computers and systems. This can be in the form of an acceptable use policy or incorporated into an employee handbook, for instance. Regardless of the format, workforce members should understand what constitutes acceptable use of electronic systems. For example, expectations with respect to social media use, software download policies, appropriate use of mobile devices, and the importance of safeguarding confidential or proprietary information, like PHI. And workforce members should not have an expectation of privacy with respect to any user activity. Identifying business associates and entering into compliant agreements is another crucial component of the security standards. Employers should review vendors and ensure that business associate agreements are executed with any vendors who are performing services on behalf of the employer's health plan that require access to PHI. As part of the security and awareness standard under the HIPAA security rule, workforce members should understand risks associated with various types of malware, what login monitoring is and its role in safeguarding the integrity of PHI, and the importance of managing and safeguarding passwords that are used to access systems or applications containing PHI. Malware is designed to infect a user's system and or to collect personal information about the user for sale or profit. A primary example would be identity theft. Malware takes many forms, for example, viruses, spyware, or rootkits. It's often spread through outdated software or downloads from unauthorized sources. This is why it's crucial for employers to make sure workforce members understand the concept of acceptable use and know not to download unapproved software or open emails from unknown or suspicious sources. Employers should also ensure that they have virus protections in place and that such virus protections are maintained and updated regularly. Phishing is another threat to security. Phishing is a particular type of social engineering that attempts to convince a user that an email, phone call, or other request is from a legitimate source and trick that user into divulging personal information. Users may be able to spot these solicitations by looking for things like poor grammar or embedded hyperlinks in emails. It's particularly important to understand that legitimate requests from banks, colleges, etc., will never ask a user to provide his or her login credentials. Workforce members should understand the importance of watching for phishing attempts and should know how to report suspicious communications to a manager, IT department, or the security official. Log-in monitoring helps identify anomalies in system activity and protect the integrity of PHI by linking specific users to specific activity. It serves as a reminder to users to never share passwords and to ensure that they abide by all acceptable use or network use policies. Like malware education and login monitoring, password management is a critical component of any security program. Workforce members should understand the importance of safeguarding passwords. For example, securely managing them and never sharing them or writing them down. Employers should have policies in place for safeguarding passwords, along with complexity requirements and requirements for periodically changing passwords. Workforce members should understand what these are. Handling breaches of PHI. As we mentioned previously, individuals must be notified if there is a breach of their PHI. Covered entities are also responsible for logging breaches and submitting an annual log to HHS. If a breach involves more than 500 individuals, the covered entity must notify the media and HHS as soon as possible, but no later than 60 days from the date of the breach. With certain exceptions, a breach generally refers to the acquisition, access, use, or disclosure of PHI in a manner not permitted under the privacy or security rules, which compromises the security or privacy of the PHI. Before HITECH, an unauthorized disclosure would not necessarily be classified as a breach as long as the covered entity could demonstrate a low risk of harm to the individual resulting from the unauthorized disclosure. HITECH changed and broadened the definition of a breach. Now, an unauthorized disclosure is presumed to constitute a breach unless the covered entity can demonstrate a low probability that PHI has been compromised using a specific four-factor analysis. The analysis considers the nature and extent of the PHI involved, including types of identifiers and the likelihood of re-identification. It considers the unauthorized person to whom the unauthorized disclosure was made in order to assess risk, whether the PHI was actually viewed or accessed, and the extent to which the risk to the PHI has been mitigated. It's necessary for workforce members to report all suspected breaches to the privacy official in order to ensure that this analysis is completed and that all such incidents are appropriately classified and handled. In addition, all business associate agreements should require business associates to report suspected breaches to the plan. So in sum, what are the expectations with respect to ensuring HIPAA compliance? First, take privacy and security seriously. Understand your corporate policies and procedures and make sure workforce members understand them too. Understand the process for and importance of reporting potential breaches. And perhaps most importantly, always ask your privacy or security officials if you have questions about any of these requirements. Thank you. This ends the presentation.